Can you change your parents' trust after they pass away, or even while they're still living, but they can't make the changes themselves? I get this question a lot, and I understand why. Maybe a dying parent made a verbal promise, or maybe the siblings want to agree to something that's different than what the trust says. In this video, I'll walk you through what's legally possible and what's not when it comes to modifying a parent's trust, even with the best of intentions. So adult children can have many reasons why they want to change a parent's trust. I've had adult children tell me that their parents actually meant to have a different distribution from their revocable trust, but for some reason the parent wasn't able to sign something stating that. Can the adult child make that change anyways? Or some adult siblings might decide that they want all of the inheritance to go to just one of the siblings. Maybe that one really needs the money. Can they change the trust to specify that? Let's look at these situations one by one. So when somebody creates a revocable trust, they're called the settlor. That person has the power to amend or revoke the trust in most situations. While the settlor is alive, no one else can change the trust. And once the settlor dies, the trust typically becomes irrevocable, which means you can't change it. So again, nobody else can amend the trust. This means none of the beneficiaries can amend the trust, and the successor trustee, the person now managing the trust, can't amend the trust either. And this is done for good reason. Usually the settlors want to make sure that their wishes are carried out, that nobody else is changing what they had written where they want their stuff to go. Now, occasionally, the settlor might put into their revocable trust that the agent under their durable power of attorney has the power to change the revocable trust, as long as the durable power of attorney also says that the agent has the power to change the revocable trust. They both have to talk to each other. And if they match, then the person named as power of attorney can change the trust. I see this happening occasionally, but it's pretty rare. Usually that's not written into revocable trust. So if a settlor wants to change a trust, they need to do a written amendment. Yes, the amendment must be in writing. It can't be a verbal statement made to somebody else. There's something in the law called the statute of frauds. This says that contracts, like trusts, must be in writing in order to be enforceable. So sorry kids, an oral promise made to a child on their deathbed is not an enforceable promise. Now let's say a parent's trust leaves assets equally to their 3 kids, but 2 of the kids don't want their inheritance. Weird, right? But sometimes that happens. Maybe they recognize that the 3rd child really needs the money, or there could be another reason. Can the kids all agree to change the trust so that all the money just goes to the 1 kid? Well, the short answer is nope. You can't change the trust. The settlor's wishes in that trust are binding. But there's a few ways we can address this. One way is that the 1st and 2nd children can disclaim. That means they can say no thank you to their inheritance. Then the portions will pass as if each of those children died before the settlor. But here's the tricky thing. You have to look to see, what did the trust say if one of the children passes? Does their money go to their kids, to their descendants, or does it go to the other siblings? If it goes to their descendants, then we're kind of out of luck because it's still not going to the 3rd sibling like we want it to. But if they disclaim it and the trust says that it's supposed to go to the 3rd or to the other siblings and they both disclaim, so it goes to the 3rd sibling, there's a solution. I talk more about disclaimers in my video called Weird Clauses in Trust. Another approach is that the 3 kids can just accept the terms of the trust and each receive a 3rd, and then the first 2 kids make a gift of their inheritance to the 3rd kid. But this can be problematic from a gift tax perspective and for property taxes. So you need to think very carefully before doing this, and please get some legal advice. Still, another approach would be for the siblings to go to court to get an order modifying the trust. Yes, an irrevocable trust can still be changed or revoked or modified in California if a judge approves it. In California, we do this under Probate Code Section 15403. I've found that a court often grants this type of petition if all of the kids sign off on it saying that they all consent to this type of change. But of course, then you're going to court, which is really a pain. I might be a lawyer, but I hate going to court. It's expensive and it's time consuming and everything you're doing is public. Yuck. So how can these situations be avoided in the first place? Well, first, if you're a settlor, if you're a creator of the trust, please don't make promises that you can't keep. I've seen families fall apart when a husband promised his sister that she would get a lot of money when the husband died, but he never changed his trust to say this. Instead, the trust said that everything goes to the wife. Then the husband died and the wife got all the money. Well, guess what? Guess how that sister felt? She was really mad, and she and the wife never spoke to each other again. The sister actually blamed the wife for not updating the trust and said, hey, I should still be getting this money. Nope. That's not the wife's responsibility. That's on the husband for making a promise that he didn't keep. Don't let this be you. Let your yes be yes and your no be no. Next, settlors, I encourage you to have a family conversation with your kids so that there are no surprises when you pass away. If your kids hear directly from you where you're planning on leaving your money when you're gone, and they understand your reasons behind that, they're much less likely to oppose or try to change your wishes. And you're also giving the kids a chance to speak up and explain why they think you might want to leave something in a different way. And then you can consider that and really have that conversation with your children. So as you can see, these situations are emotional and complicated. And it's easy to assume that you can make changes to someone's trust when everybody agrees. But trusts are legal documents and they don't leave a lot of room for improvising. If you're navigating a trust after a parent's death or trying to figure out what's possible during their incapacity, please reach out to our office. We help families all across California with estate planning and trust administration, and we're here to help you do this the right way.
If this video is helpful for you, share it to someone else who might benefit from it.